What is the public charge rule in the context of immigration cases? Well, if you think about it conceptually, there's a lot of family-based immigration. More than half of the immigrants coming to this country come through family. And there's a concept in immigration where we want to make sure that somebody who comes in because a relative is asking for them to come is not going to become a public charge. That means that they're not going to receive welfare, food stamps, public benefits at the cost of U.S. taxpayers. So that when a U.S. citizen or a permanent resident wants to bring a relative over here, as part of the application, they have to file sponsorship paperwork and they have to show they're earning enough to make sure that this immigrant won't become a public charge. They won't receive welfare. And if they do receive welfare, the government can go back to the sponsor for reimbursement. These contracts, the sponsorship contracts, are ironclad three-way contracts between the sponsor and the immigrant and the U.S. government, and they cannot be broken even in a divorce between a U.S. citizen spouse and an immigrant spouse. So this is the way that the U.S. has conceptually protected its taxpayers with the idea of family-based immigration and having people come in, but making sure that they don't take resources from the U.S. government. So the public charge rule is a rule that protects U.S. taxpayers from immigrants who might come in and then qualify for public benefits. The reality of the situation is that many immigrants don't qualify for public benefits anyway. For example, in order to qualify for temporary assistance for needy families or CHIP or Section 8 housing, an immigrant will have to have already had their green card for 5 years. So we've conceived of this public charge rule as more of an idea than a necessity, honestly, but the idea is that the U.S. citizen makes sure that the immigrant doesn't need welfare, and they do that by showing that they're earning more than the poverty guidelines, which is about $20,000 for a family of two. So they demonstrate that, and then the idea is that if this immigrant has needs after they get here, they're going to rely on their sponsor and not on welfare benefits to support themselves. So we have this public charge rule in immigration that says that if somebody, a U.S. citizen, wants to petition their relative, they have to sponsor them, and that the government could go back to the sponsor for reimbursement if the immigrant receives welfare or public benefits. The reality of the situation is that immigrants can't really qualify for public benefits. They have to have their green card for 5 years, and unless they commit some major fraud, they're not even going to receive public benefits. So could the receipt of public benefits affect an immigrant? Yes, potentially, but if they're telling the truth on their application, they're not going to receive public benefits. And if they've committed fraud on a public benefits application, that is what's going to cause problems for their immigration case, not the fact that they receive public benefits.